the No State Project, back here live from the fortified compound in Mesa, Arizona. Glad to be with you. I'm Mark Stevens, your host for these 3 hours of Anarchy Radio here on the Liberty Radio Network. Live pretty much every Saturday from 1 to 4 Pacific time. Like last week I was, even for another couple weeks here in Arizona, I will be on Pacific time, 4 to 7 Eastern Standard Time. And of course it's Sunday morning down there, down under in Australia. So appreciate everyone down under tuning in. And wow, let's get to things here. I was not able, apologize, had some personal issues, was not able to do the Wednesday broadcast. I was in California, and that's just the way it is. If I'm in California, I can't do the Wednesday broadcast. Even if I took my computer, I don't have nearly the internet speed, upload speeds that I do here. So yeah, that just wouldn't work out. So, but I don't foresee that happening too often. I will be live for this coming Wednesday. I don't know, was it the 24th, 25th? I can't even count at this point. It's been just one of those weeks. But if you want to join me here on the big show, it's 218-632-9399, 218-632-9399, the passcode 2020 with the pound sign or the hashtag. So 2020 with that. It should be in the recording when you call the line there. But you can also get me on Skype. It's Frank Rizzo 3. Frank Rizzo with the number 3. Do not just call me. Instant message me there first. We could also put you into the No State Project Skype chat, which, let me take a look over here. How many people we got in that damn thing now? Did we hit 400 yet? Holy crap. We got 397. And for the most part, everyone that's in the group there has had experience. That's why we go there. That's why everyone is there now, pretty much because they needed work on prepping. They need to work on prepping for court, and that's what we have to do. People who have already been through it know what to expect and how to challenge you, and have used the Socratic method in the lion's den. They've gone toe-to-toe with these psychopaths. And it kind of brings me to one of the things I wanted to talk about here. And, look, we've got to accept things. We can change things, we can work to change things, but that only, it's more effective to accept things as they are and then work towards, changing that. And look, I'm sure most of the people listening here are because they're interested in voluntarism, anarchy, getting to a voluntary society. A lot of people coming to the show to learn how to defend themselves in court. And we realize, especially even if you're not an anarchist, if you use the Socratic method and you don't give a sacred cow to these people who call themselves government, if you're challenging their assertions, you're going to find out really, really fast that these people there's something wrong with them. They don't interact with people like normal people do, unless by normal you mean a bully. Because that is exactly what they are. They're bullies. Of course, it's not every single one of them, obviously. Not every one of them is like Dick Noble up in Michigan. They're not. Or Crescetti in Ohio. Oh, no, I think that was Vermont. They're not all like that. There's a spectrum. Just like with psychopath or psychopathy in general, there's a spectrum. And unfortunately, look, this is the way, the facts are the facts. What we call government is just a word or a symbol for a group of people, men and women at this point, that force everybody to pay them. Those are the facts. They're men and women who force strangers to give them money. Now, they do it under the guise I'll give them, hey, they got some good PR. They do it under the guise of protection. those in the United States or, where my people are from, Italy or Sicily, that they go, well, yeah, there's other groups of people who force strangers to give the money and offer protection. It's called racketeering. It's called an extortion racket. And that's because, unlike the mafia doesn't have as good, public relations as those called government. Those called government, yay, it's okay. It's legal for them to do it because they erected a new moral code so that they can excuse their immorality by just saying it's legal. Or, it's legal or illegal, or for the patriots still listening to my show out there, lawful. As if there's a difference between legal and lawful. To me, it's all the same stupid thing. It's their rules. Their rules. They're just creating them. They either mimic our, society's basic moral principles, or they conflict with them. So, okay, so we have to accept the facts. They are just men and women forcing us to pay them. If you're learning to defend yourself in court, you're going to do yourself a major, major advantage in your effectiveness by being skeptical and refusing to accept their claims as true. You have to treat them and you have to deal with them in a manner in which you can prove it. Just like there's a line from A Few Good Men. It doesn't matter what I think, it only matters what I can prove. And when they attack us, this is what we have to keep in mind. When they attack us, think about it. Even if it's a parking ticket, which can escalate depending on where you are. And you may think, well, it's just insurance. How is that an attack? Well, I tell you, if you're one of our Canadian friends, that's a $5,000 to a $10,000 penalty. Yeah, I've seen the transcripts. I'm not talking out of my, that's true. Anybody in Canada who's been through this can back me up on that. In a simple search, here, let me Google that for you, I think is the phrase. $5,000 to $10,000 for a traffic fine in Canada for not having insurance. And we've had someone call the show about it. Oh, that wasn't Canada, though, but it was a pretty damn steep fine. Nonetheless, very, very steep. This is, and I'm going to be doing a video. I got a video I'm going to be putting out, and it's going to include a lot of what I talk about to be more effective in court. Look, people think that local prosecutors and cops that are filing these complaints against them, that they're just ordinary, regular people just doing their job. And the only ones who would really say that, or continue to say that, are those who have not engaged that system. Anyone who has actually questioned these people, daring to question them, except in those limited circumstances, is going to find out very, very quickly there's something wrong with these people. They are not acting like regular adults. You are not supposed to fly into a fit of rage because somebody asked you a question and asked you to prove what you said. That's not normal behavior. I don't think so. I mean, hey, you don't have to be a clinical psychologist or psychiatrist to know that that's not normal behavior. Because it's not. It's sick. We're going to talk about that in psychopathy and how to deal with this in court when we get back, so don't go away. So we're talking about here defending ourselves effectively against these criminals who are criminals because that's what the evidence tells us. Follow the evidence. What does the data say? Well, when you force strangers to give you money, that data tells me one thing: crook. Now, whether they're psychopath in nature, that remains to be seen. I'm not saying that they're all psychopaths or sociopaths. However, they tend to strongly exhibit character flaws or flaws in their personality and their behavior that are on the psychopath spectrum. And what I mentioned before the break is they do not handle challenges well. It is not normal behavior when someone asks you a question. So if you make a statement that X equals Y, and someone says, do you have any proof of that that's true? Can you actually prove that with evidence and a rational basis? To fly into a rage because someone asked you to support your claim, that's not normal behavior. And we have... Many of us have experienced this firsthand. A lot of people have called into the show, and because that's what you can expect. I'm not trying to discourage anyone from defending themselves, because obviously we should be doing that. We should be challenging these people in and out of court. But you have to expect that because you're dealing with criminals, one or more of these people may not take too kindly to you asking them a question. But know in advance that to expect that. They just don't like being challenged. So I know they're calling it a conduct disorder. It comes under the psychopathy threshold spectrum. To me, this just sounds like it's a part of, almost every bureaucrat I've ever encountered, especially prosecutors. Prosecutors tend to be even worse than the judges. And so they say the DSM-5 includes a specifier for those with conduct disorder who also display a callous, unemotional, interpersonal style across multiple settings and relationships. The difference here is the psychopath is not unemotional. They're callous, yeah. They're not necessarily unemotional. I think they tend, when they are hurting somebody, to not be very emotional about it. But when you challenge them and you do something as heinous as asking them a question in their sandbox, that's when they'll throw you in jail and order a psychological evaluation and not even remember your name by the time they go home. Well, I get that. That's part of the callousness. But when you challenge them, that's why when you go and you hear my interview with Robert Diab, who is the doctorate of law, or the law professor up in Canada, he doesn't fall in that spectrum. And you could argue, but Mark, you weren't actually challenging his arguments. You weren't challenging his claims that he was making against you to further his career, like some prosecutor. I was still making challenges to the very system that provides him probably a very comfortable life. And if you haven't heard that, and a lot of people haven't, unfortunately, I have a law professor actually admitting that there's no evidence to prove that these laws apply, that it is nothing more than a blunt assertion of power. And there are reaction videos that get 100 or 1,000 times more views. It could be very, very disheartening if you... okay, anyway, so let's get back to this. So one of the things I want to discuss, this is something that came up, and he wasn't able to call the show about it. So Scar had Skyped me before, and this is a common problem, and I believe James up in Alaska is dealing with this situation too. And the thing is, what do you do when one of these psychopaths, and yes, they're let me just explain. The psychopathy has to do with being a callous disregard for others, not taking challenges very well, having a very, very short fuse and prone to fits of rage, and just not having any empathy. and constant lying and manipulation. This is the hallmark of psychopathy. Callous disregard for others, constant lying and manipulation, fits of rage, not handling challenges very well, not having adult coping skills. Other people are just pawns to be used. War Pigs, written, of course, by lifelong vegan Terry Butler, a Black Sabbath. Using people just like pawns in chess. That's what they do. So that's the basis of calling them psychopaths. So what Scar is mentioning is something that a psychopath will do. Is it really a surprise when you go in, and Scar's got a damn good record, by the way, everybody. He's 3 for 4 of getting things thrown out. 3 for 4 is it's pretty damn good. It's nothing to sneeze at, all right? That's a good track record. Non-lawyer, by the way. 3 out of 4. Yeah. He deserves an attaboy for that. Of course, any of us would. And when you go in like Scar was doing and you do effectively challenge, there are tools that these people have to shut you up. Yeah, it is the obvious one. They just hold you in contempt, or they threaten a psychological evaluation. How dare you challenge a lawyer's opinion? What kind of... And that's the thing. It's the flippantness. It's the friggin' arrogance of these people. How arrogant do you have to be to think that somebody deserves a psychological evaluation for doing nothing more than asking for the evidence a lawyer's opinion or claim is based on? Wow, that's some serious arrogance there. Again, for those who are new, I'm not doing anything. This should not discourage you, because this is very, the psychological evaluation is very rare. It does happen. I just want to give everyone an understanding of what we're dealing with and why we should not take any of their claims as true. What to expect when we do go in there. Well, we're up against a break. I'll be back here on the No State Project talking more about what to do to defend against these psychopaths in just a few moments. Don't go away. So welcome back to the No State Project, here live from the fortified compound. It is October 21st. I'm glad to be with you here. The website, of course, is markstevens.net. If you are looking to learn how to defend yourself against bureaucratic attacks, you've come to the right place. We have at markstevens.net plenty of actual evidence of success on 4 continents. And speaking of, because of Israel, I want to thank Eyal for his continued support of the show. And Eyal does No State Project Israel. I appreciate that. And everyone who does help support the show. You could do so by going to my sales page. What we're talking about, learning how to effectively defend ourselves, begins with being a hardcore skeptic. And I don't mean like the skeptics at the Skeptic Society that I reported on about 6 months ago, who, I'm talking about not accepting anything politically or what the prosecution and the cops or the judge say. You don't take anything at face value that it's true. If they give you the time, you should check that yourself. Double check it, because you'll find that they have a very difficult problem being honest, truthful, and upfront. So what I mentioned before, of course, which is a very small part of what we've had reported here on the show, with judges threatening people with contempt, sometimes actually putting them in jail for contempt for asking a question. And look, this is just part of the criminal nature of the people that we're dealing with. It's a very small part, but we have to go into these things knowing in advance that this is possible. Now, it doesn't matter whether you're working with me or an attorney or on your own. It doesn't matter. Every one of us, when we set foot in court, may not walk out that day. I mean, there was a judge in New York a while back that threw 40-something people in jail because a cell phone went off. So that's a risk that is going to be there until we have an anarchist or a voluntarist society. It's going to be there. So it's not a strike against what I do. Challenging their view of the world, that's going to, in a very small percentage of cases, situations, you meet up against a Dick Noble who is not going to tolerate it. And that's why if something like that happens, you make your objections and file a motion to disqualify the judge as soon as possible. But then you can use his statements against him. Why it's not possible to get a fair trial from somebody who is who it flies into a fit of rage because you're questioning the prosecution. And that's something too. When we go in, we're challenging the prosecution's claims, not necessarily the judge's. The judge's insistence that there's jurisdiction has to be based on the prosecution's evidence to prove that, not that because the judge is just a impartial, independent decision maker. I don't get people laughing about that. So knowing that they don't accept challenges very well, how they have these tools that they can use to muzzle us. They can use overt violence and threats. That's very true. They also, in a very small percentage, maybe just a handful of people in the last 10 years have had this happen to them, where the judge forces you to have an attorney. They can do this where they force you to hire your own attorney, or they force a court-appointed attorney on you. Now, this could be someone from private practice, or it could be from the public defender's office. And they'll force you to pay for it, too. And that's the whole thing. Really, something came up the other day, and it was one of these things where they they get all upset that you and I may not know the proper terminology for their court procedures, right? How damn arrogant do you have to be? Now, something like that comes up. What I would do is I would say, well, objection. The fact that I don't understand your procedure here is no reason for you to get pissed off at me, you jackass. How about this? Why don't you act like a normal adult human being for one moment, okay, and realize you were the one who forced me into these proceedings. So if you don't like that I don't understand your proceedings, here's a clue, jackass. Don't force me into the proceeding. Okay? See, I don't know all the rules that they have for college football. It would be ridiculous to kind of force me into that proceeding, even let's say as a ref or something, or some kind of participant, and then get pissed off at me like, dude, you don't know anything about the rules here. Yeah, I didn't ask to be here, you moron. The hell is wrong with you people? But that's one of the things that they do. Again, arrogance, the flippant attitude. Oh, you're upset that I don't have the grasp of this ever-changing set of rules that you change every 6 months or more? You're upset about that? See, normal people wouldn't force you into that situation. Yeah, can you imagine being forced into a medical situation? Dude, you don't know how to do a simple suture? Nope. Why did you force me in here? What were you thinking when you forced me in here? Oh, that's right, because it's not about fairness. I was supposed to understand these rules that change change every time another decision is made by the exalted priesthood, and you're upset. You're upset that I don't know that. Again, criminal minds here. Okay, so what they do is, guys, see, I'm doing all right. I'm getting back to my point here. They force an attorney on you. And how can the judge force an attorney on you, especially when it's traffic? Well, they can do that because the judge is the top guy on the totem pole in the courtroom. He runs the entire show. They all work for him. But my attorney doesn't, the public defense. Oh, yeah. Because lawyers are officers and counselors of the court first. Oh, where's your proof of that? They take an oath. They take an oath of office. They are officers and counselors of the court. They're not necessarily paid directly by the government. They are still a part of the court system. And the judges are in charge. Because if there's one group of people that judicial conduct commissions take serious and that the Bar Association takes serious when a complaint is made against a lawyer, it's by a judge. They even told me, the Bar Association even told me in writing in California, they will not take a complaint against a prosecutor for misconduct unless there is a ruling from the judge. Yeah. So, and anyone who's dealt with the Bar Association and complaints from lay people like us against lawyers know that they don't take it serious. It has to come from another lawyer. And it's given no regard if it's against a prosecutor. Prosecutors are just too powerful. They can ruin anyone's life. So keep that in mind. The gall to these people. That just kills me. You don't understand the rules? Yeah, well, I didn't ask to be here. I mean, hey, well, we'll be back here on the No State Project in just a few moments. Yes, welcome back. I'm Mark Stevens, author of Government Indicted, available at markstevens.net. A full model on how to deal with these criminals called government. And yes, they are criminals because they force other people to give them money. I don't give a damn if it's legal or not. Well, of course a criminal is going to excuse all of his criminal acts. I mean, gosh, for heaven's sakes. Of course. And they're not going to want to be questioned on what they're doing. They don't like it. So what they can do, like I'm talking about here today, they force a mouthpiece on you. And this is bad. Because what do you think the chances are of the public defender who works for the government, this gang of killers, thieves, and liars? What do you think the chances are that they're going to challenge the foundation of the prosecution's case? He's going to actually challenge the police officer's determination of probable cause at its foundation. He's going to strike the root. That'll sound just right depending on where you're listening. He's going to strike the root. Really? You think he's going to do that? No. He's going to give the prosecution a free pass on that. He's just going to assume it. He may even say, well, we're just going to, they'll just pull out other cases where the courts have struck down jurisdictional challenges. Well, here's the thing. They may do that, but every case is fact-specific. So unless they were striking it down on factual grounds that there wasn't, that the prosecution had sufficient evidence, then it's probably not applicable. But you know what? You could turn around and say the same thing about a Fourth Amendment claim. Hey, I'm going to file a motion to exclude. This is a violation of the Fourth Amendment. Well, they're just going to they're just going to counter that with cases where the court overruled and ruled against the Fourth. Yeah, you can say that about any legal argument. Oh, I guess that's a built-in part of the system to keep always have controversy. Always have a controversy. So they force an attorney on you. What do you do from this point? In some respects, like when you're on appeal, I think that what happened with our friend James in Alaska, if you can't get a decent attorney who's going to work with you and raise issues to get it reversed, you are probably screwed. There's going to be circumstances where, and this doesn't happen very often, that's why I don't have I have James and we have David from back in 98. It happened to him with Mark Aceto. I've mentioned him before. I've mentioned Mark Aceto, that criminal. I even have a picture of him in one of the videos that I recently did, because I can't ever forget what this SOB did. He would not allow the public defender to withdraw. And that's, of course, because the judge is in charge. He is in charge. Well, Mark, the judge is a fair, impartial, independent decision maker. He's kind of the referee. He's got to make sure that everything runs smooth. Yeah, but by forcing an attorney on you or not allowing an attorney who is antagonistic to you, by forcing you to work with them, that's not, that's not helping the administration of justice. Because that's supposed to be the end goal. I should have a laugh track with this. I have that somewhere. So anyway, what happened there with David, and I've reported this on the show before. Worst case scenario, we were able to we couldn't get the presiding judge to do anything about Aceto. Nobody would step in to stop this guy from forcing the public defender on David. And it did go up on appeal. And the Court of Appeals initially took jurisdiction and then said, no, we're just not going to hear this. And we went into the Arizona Supreme Court, who initially did take jurisdiction and ordered a response from the county attorney. And the county attorney filed basically 18 or 19 pages, basically just saying frivolous. It was absolutely frivolous. And the Supreme Court disagreed and said, no, it's not frivolous. I mean really, when you get a $150,000 education, is it really taught that to defeat an argument, to just say frivolous as many times as you can? I mean, is that really what a Juris Doctorate is giving you? Frivolous! Frivolous! It's frivolous! Go F yourself. God bafungal with these people. Do something to address the actual issue instead of just screaming frivolous 100 times. And that's basically what they did. I think it was something like, in 18 pages, they had said the word frivolous something like 85 times. I think it was a record that at the time. Supreme Court of Arizona disagreed with the county attorney and did say it's not frivolous. The matter has merit. And for no reason whatsoever, the Supreme Court just wrote, we are not going to hear at this time. They didn't say the issue wasn't ripe. No. They just said they weren't going to hear it at this time. So, of course, we didn't even bother going to the U.S. Supreme Court because it would have been a complete waste of time. So, unfortunately, David had to go through trial with an attorney who was openly antagonistic to him. Openly refusing to present evidence of felonies committed by the police officer that were backed up by 5 witnesses he refused to call at trial. So I'm giving you an absolute worst case scenario, and I got to go back to 1998 to just how rare a situation this is. So what you can do is obviously speak with the attorney and see if they're not willing to withdraw, if they're willing to at least be standby. Now, there is a catch to that, and there's nothing we can do. The judge may say F you. The judge may say fungal. They can't. They're not going to allow the attorney to go standby because standby allows you to defend yourself with assistance of counsel, like their sacred document says, right? You can both make argument, you both can make objections and file paperwork. But they may not want you to do that. They call that hybrid representation in California, and they don't even allow it. So the whole thing, defending yourself with assistance of counsel, no. They have taken that to mean you can either defend yourself or a lawyer will do it. There is no ifs, ands, or buts about it. You're not getting assistance to defend yourself. F you. So that's the way it is. Because if you want to talk about bias, look at how much judges and prosecutors cannot stomach the sight of a non-lawyer defending themselves. And the idea of a non-lawyer assisting somebody turns their stomach. They will actually have, I've been through this myself many times, they will actually have sheriff's deputies aggressively approach you with the hand on the gun if you dare, as not be a member of the Bar Association, if you dare try to go in front of the bar. And I spoke recently to James about this, how Tom Bradley, that prosecutor up in Alaska, how he came unglued when all I did, the jury was gone, the judge was gone, everybody was leaving for lunch or whatever it was for the day, and I was helping James get his books and whatnot, and this guy came unglued. I get a grip, people. Man, talk about insecure. Yeah, you're talking about a prosecutor. So, like I mentioned with Dave, what you can do is you can file a motion with the presiding judge to get some intervention so that you can defend yourself and not have to work with that prosecutor. If that doesn't go anywhere, you've exhausted your remedy in the trial court, you have no choice. You have to file, like in Arizona, you have to file a petition for special action, because in an original proceeding, you're not represented by counsel, and you can file your own paperwork. And that's an option, one of the few options, if not the only option available, to get this judge's decision changed so that you can defend yourself. In Arizona, it's a special action. And in, let's say, places like New York, it is an Article 78 proceeding. And that may be our only options to get that changed. But anyway, we're up against the break, unfortunately. It's top of the hour break. We'll be back with the second of 3 hours of Anarchy Radio here on the LRN.FM. We'll be back in just a moment there, so don't go away. What I was talking about before was this unfortunate situation that comes up very, very rarely, but it's extremely stressful, because you can have a solid defense, and challenging the prosecution's claims and starting with the foundation that they think that just because you're physically in Arizona, their laws apply, and that gives them jurisdiction, which applies to the police too. It's not just a matter of the court's territorial jurisdiction. It has to do with the territorial jurisdiction of the police. The police have jurisdiction to do what they're doing. So keep that in mind. Jurisdiction doesn't just apply to the judicial branch. It applies also to the other two branches, whether it's legislative or executive. Do they have jurisdiction to do X, Y, Z? And that jurisdiction is predicated on whether the Constitution applies, because their authority, their jurisdiction is based on the Constitution. 4 pieces of paper, no one bothered to sign. Well, we're talking about how they muzzle you because they don't want you to be challenging the foundation of the prosecution's case. We know that. We know they don't want to. We know that the prosecution doesn't want to be held to that. Prosecutors will claim they don't have to prove that. And I've addressed this before. So for new listeners, just when the prosecution says they don't have to prove that an argument they're making against you is true, then you just object and fire back if you're allowed the same privilege. Well, why not? Well, why can't I argue against you without evidence? How come you're given that pass? And why is the judge giving you that pass? The answer to the question, of course, is why the prosecution shouldn't be doing that. And they shouldn't be doing that because it's not fair. Because when you make an accusation, you bear the burden of proof. Whether it's by a preponderance of evidence or beyond a reasonable doubt, it still has to be based on evidence, which means you have to have information that proves the proposition is true. So some may say, well, who gets to decide what's evidence and what's information that proves a proposition is true? Well, the basic principles of logic do. Don't buy into this garbage that legal logic is somehow so foreign and different than regular principles of logic. The principle of causation is very, very much a part of the legal system. And that's because when they're doing real crimes, you'll see Causation is very important, a chain of causation. And you'll know in tort law or criminal law that any time that the chain of causation is broken or there's a gap in there, you've got a serious problem trying to find out who is responsible for the actual damage. So the basic principles of logic are going to dictate if the information rises to the level of evidence actually proving that a proposition is true. Basic principles of logic. You're not supposed, your logical fallacies, that something is not true just because someone says it's true. And again, if a prosecutor is going to, or a judge is trying to make out that is legit, then they have to let you do that. Well, you're saying that, this is true because you say so, and I'm saying I'm not guilty because I say so. At the very least, they have to. Well, then we have a serious problem here. We have to have a trial to determine which one is valid, and you have that trial to determine which one is valid by putting out the evidence on the table and the witnesses and cross-examining and challenging that and seeing which one really is true. So they force a lawyer on you so that your defense is limited to only something that the judge is going to allow. Something that a prosecutor and a public defender are more than happy to address. It's not going to be something that's going to challenge the basic legitimacy or the facade of legitimacy that they are putting out and hope that you don't challenge. So the public defender is not going to challenge the foundation of the prosecution's case. He's going to give them a pass. And that's why I say this so often. They have to contradict themselves when you ask them about how to generally effectively defend yourself against these charges, these claims. That you have to challenge them zealously. You have to challenge the prosecution's claims. You cannot give the prosecution a free pass. Nope. You have to challenge the foundation of the prosecution's case, which hinges on the claim that if I'm physically in Arizona or physically in Toronto, that their laws apply. And then they'll say they have to contradict themselves. No, you have to give them a pass on that. Oh, so now we determine that you're not too consistent in your principles there, tough guy. So what other free passes do I need to give the prosecution, and why should I do that? And ask them. So to effectively defend myself, I have to allow the prosecution's claims to be accepted as true. Well, that one you do. Isn't that the foundation of the prosecution's claim, though? Well, yeah. Is anything relevant if that's not true? Well, yeah, you've raised a serious issue of relevance, and if it's not relevant, is it allowed? Well, technically, no. Then why, if I'm trying to effectively defend myself, would I allow a free pass that gives relevance to everything else the prosecution is saying? So if you can knock out the foundation of relevance, wow, you're doing pretty damn good. If you can show that nothing the prosecution has is relevant because the foundation, the threshold issue hasn't been met and proven, you just defeated their whole case. So that's why they force an attorney on you. Well, where's your proof that that's why they do it? Really? Well, let's look at it circumstantially now. You're in a traffic situation, for example, and they want to force an attorney on you? Is it so that you have the best defense available? I would argue no, because they want to give the prosecution a free pass. They're not even going to question the police officer on his prior statements. Now imagine that. We know from experience that questioning the police officer on his prior statements, which include legal conclusions that the laws apply because you're physically in Arizona, and we know the prosecution will always impeach their witness, yet a public defender won't do that. So the fact that the public defender is not going to challenge the foundation of the prosecution's case and is not going to challenge the police officer's prior statements, that's a pretty big indication that they're not doing it because they have your best interest and that they want you to have a better defense. If they allowed him to be standby, then you're making a strong case. That's not the case, though. It's not the case. They're doing it to muzzle you. They're doing it to shut you up. Circumstantial evidence is pretty overwhelming, I believe, to make a pretty firm case there. They're doing it to shut you up. And so these are the only options we have when they do something like that, which is extremely rare. I guess we have to talk about it because it does happen sometimes in a very handful of situations. So we need to know how to be prepared to possibly defend against that, because otherwise you're screwed. You've got a mouthpiece that you're not in control of your own defense. So your only hope is on appeal, you're able to do it yourself. But we'll talk about that in a moment. We're up against the break. We'll be back here on the No Stay Project in just a moment. What I was talking about, and James and Kevin have asked about this, on appeal, let's say, you're able to, when you take the appeal, do you run the risk of having a new trial ordered where you can have more of a fine if you're convicted a second time? Yeah. Yep. That is something that they can do. Yeah, of course. Consider, they may, I can only speculate that they're going to figure, well, you made us do this twice, you cost us money, you're going to really pay for it. So, but you also stand the chance of, if there's a new trial, of one doing a better job and possibly getting getting it thrown out. So you look what happened in West Virginia, the situation that was cherry picked by that disgraceful excuse for a human being, Wesley Serra in New York, the ambulance chasing attorney. They went up on appeal, got a new trial, and they filed the paperwork. They were able to get it tossed out. So the cherry-picking Wesley Serra won't tell you that it was a new trial. He just lies and said that it was the appeal that was tossed out. No. The underlying, the original complaint was tossed out. So when you go up on appeal, yes, you are running the risk of being retried and getting more of a fine. However, when it's traffic, it's still up to the prosecutor if they're going to. They don't have to retry it. They can withdraw. So to me, I guess it depends on the situation, and you'd have to make your mind up. Look, am I going to cut my losses here, or am I going to take the chance, just like I did before? I fought this and was, and when every time you fight, you are risking having more of a fine. You just it's not something I can answer. It depends on the situation. It depends on why you're doing it. If you're an activist and it's not about the money and it's on principle, great, go for it. If you just can't deal with let's say it's a $10,000 fine, like if you're in Canada, for insurance, and you can't take the risk that they're going to double the fine, then that's a choice you have to make, and it's going to have to stand. I hate to see something like that, but it depends on the situation there, on what you're going to do. So it's really unfortunate, and I understand as somebody who I do a small show here. I'm not like some that are sitting on millions in Bitcoin. I understand what it's like to be living week to week. So you may not be able to. Hey, sometimes even the fact that depending on where you are, like New Hampshire, the cost of the transcript is prohibitive. And so you may not even be able to appeal it because the transcript is so damn much. So it kind of depends on the situation. So I wish I had more to offer there, but at least as far as if there's an attorney forced on you in the appeal, you'd have to do the same thing. You'd have to you'd have to file a motion to have the attorney withdraw so that you can defend yourself. And if the appeal court tells you, you're screwed. You better hope that like with James, who got a fairly decent attorney who made some pretty good issues, that's willing to work with you. So if not, you're pretty much screwed, and there's going to have to be some other remedy. Maybe and I'll talk about this after some calls, but we do have, filing an insurance claim to recover the fine. because there it could be pretty significant, especially if you're in Canada or one of these insurance where they want $5,000 from you. So anyway, let's get to the calls because, wow, holy crap, we're almost halfway done with the show. We don't even have a call. What we got, it looks like, I think it's Connecticut, but area code 203, you're live on the show. What's your name? Where are you calling from?
George. I'm calling from Stamford, Connecticut.
George from Stanford. How you doing today?
Fine. I had a really nasty experience. I was leaving from Fort Lauderdale when that great, just a couple of days after that great incident down there where somebody shut up the airport, and somebody put a laptop in the tray that I had when I was leaving TSA, and I was the last one to leave because I don't do the body scanner thing, and so I had to wait for everybody to go through the line. And there was a laptop under my things, and I said, what the hell's going on? I thought maybe the person just left and didn't realize it. So I'm going to the airline looking for somebody that may be coming back, in a rush, hey, I left my thing. Nobody did. Everybody was going to New York, Westchester or wherever. And I figured, it's a Apple, so no big deal. I can get the serial number and call this guy from the Apple store, once I arrive. I arrive, and that's exactly what I did. Since everybody mostly came from Westchester, even though I'm from Connecticut, it took a 40-minute drive to go to the Westchester Mall, which you may know since you know the area.
Oh, no.
And
no.
Went to the Apple store.
No, I'm from Long Island. I don't know much at all about Westchester.
Oh, I thought you might because you were from the region. Okay, but anyway, the Westchester Mall. Go there, and they give me the runaround. They didn't give me the runaround. Actually, the sales lady was very nice. Started to give me the information, but then the manager pounced on her. Oh, you can't give that personal information out, so you can't. Well, I said the guy lives probably, and she confirms he only lives 10 minutes away. Why can't we at least help him out? And he says, no, you can't give that. So I said, this is after I got this. So I said, okay, screw it. I'll go to my friend who's an Apple user and see what he says. And so I go back to Stanford. He says, why don't you go to our local one? I know the guys in Westchester, but they wouldn't give me any information. So he said, so I go to the Westchester, the Stanford Mall, and at the Apple store, and they say, sure, here's the guy. We have it. We email him, and I said, okay, I'll give you the laptop, and I'll come back in a couple of days. And if they come back in a couple of days, and they email him back, and he says, yeah, he's going to pick it up. And there's a couple of witnesses there, the other employees, and I thought that was that. So I go on my merry way, figuring this is going to get back to the guy, and then all of a sudden, a police officer calls me from the Fort Lauderdale police and says, "We saw you on tape, and we know that you stole this, blah 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 blah." And I says, "What are you talking about?" And first, then he's trying to, entrap me.
I was waiting to see where this was going to go. We're up against a break, George. So just hold tight for a moment.
Sure.
Yeah, this took a different turn than I was expecting. This is actually not as bad as what I was thinking. But we'll be back with George in Stanford and here on the No State Project in just a moment. You want to join us, it's 218-632-9399. The passcode is 2020. So we'll be back. Do not go away. Now we're talking with George in Stanford. So what you're saying is the police in Tampa called and said that they have you on video stealing the laptop.
Fort Lauderdale.
Oh, Fort Lauderdale, sorry.
Yeah, they had me on video, but what the ridiculous thing is, they never mentioned that the stuff that this was put in my stuff. I didn't take it from somebody else. It was literally put in my stuff. So had I picked it up in a certain manner, it was a very small item. I might have just not even known it to be for that matter. But anyway, I don't want to argue those points. What the main thing is, I finally I delivered it to this person in the Apple store, and then and he acknowledged that. I went back a couple of days later to confirm that he contacted the person, and he said the person contacted him back, and he was going to pick it up in a couple of days. And I thought that was that, and that's what after that the officer called me back. and said, still trying to accuse me. And says, "Oh well, if you just return it, everything's okay." And I'm saying, "What's going on here?" So finally, I mean, this was later on because I ended up going in the hospital in between, so there was a delay in between. But later on, I went back with a friend to make sure that the guy in the store had done what exactly he said he did. Let's face it, I don't know. I'm assuming the guy is honest, and he said that perfectly straight out in front of a witness, and I had a digital tape. So I'm assuming he was perfectly honest, and I'm going to go back tomorrow to check that out. But the point is, just a few days ago, I have a couple of thugs coming at my door, claiming that I'm a fugitive from justice, arrest me, I have to bail out, and so what the frig is going on? The computer was less than a $300 computer, and no more than $600, no matter what you look at it. And the state law says they can't extradite you, or it isn't a felony unless it's over $1,000. So what the hell's going on?
Well, didn't you say it was a MacBook?
No, it was one of these little tiny things. And I looked online, and all of them under eBay, even under Best Buy. Only the newest models with all the bells and whistles is slightly over $2,000. Not $2,000. I'm sorry, $1,200. But by the time you get it out of the store, just like a new car, it's less than $1,000.
Are they trying to So, well, you've obviously bailed out. So
yes, but I have a hearing so that I don't get extradited. And what's ridiculous, the owner is in Westchester. I'm in Stamford. I have witnesses that can confirm I was trying to track this guy down, that all the witnesses are here. So why would they try to extradite me to a city when I have a right to confront my accuser, and everybody's here in this region? If he wants to say I stole something, he should at least apply in Westchester, which then we can bring all the witnesses and all the stuff with us, rather than what the heck is with Florida? What are they, crazy? Especially if something's under $1,000, it's going to cost them more for the airfare.
Well, you just answered your own question. What are they, crazy? It's Florida.
Yeah.
There's a whole thing about Florida man on Reddit. Some of the craziest thing. Well, I'm hearing a feedback there. Some of the craziest stories come out of Florida. We had one woman where she had a baby that was only a few months old, and she was she as a mother, she's a new mother, she nursed her baby, and a judge, because she was questioning the prosecutor's claims, wanted her to be incarcerated for a mental evaluation, have her child taken from her. That happened in Florida. So it does seem, because you would think that the guy who's doing this would realize, well, I got it back. It seems like he tried to get it back. I don't want to go to Florida to testify against this guy, which he will have to do.
No, he supposedly, the police officer, this is what I got from my friend who actually spoke to a detective in Connecticut, and then they called down there. Supposedly, the guy said, "Where's my computer?" So that's why I went back to the store with my friend earlier to make sure nothing like this would happen. But I guess, even the best laid plans, to make sure everything is all, T's are crossed and dotted and all that great stuff. It still seems that it's nutty. But I'm trying to find, how can he get jurisdiction if the party, the complainant, there was no proof, there was no, what's the terminology? There's no proof that I had a state of mind to steal anything, and everything that proves that I was looking for this person and also went to several stores to try to get this person. So there's no state of mind that he can prove that I was stealing this thing in Florida. And if there's any complaint, whether it was negligence or whatever, that the thing was lost in my possession, then it should be done in New York or Connecticut. Since the guy who owns the laptop is there, where is Florida sticking their nose in this?
Because they're saying that the actual crime took place there, and it's all by territory. Wouldn't the video evidence show exactly what happened, that he had left it in the bin?
Well, that's what I would think, but the real question is, how did it get in my bin? I didn't take it. It was literally under my things or between my things.
So you didn't put your stuff on top of
No, that's why I'd like to get a copy of the videotape, because that would prove that, hey, what the hell was it doing in my stuff? I didn't do it. I didn't put it there.
Oh, yeah. Well, that what sucks is that would have to come out in discovery if they're not willing to give you a copy. Otherwise, because the video absolutely will show what happened. Well, depending on who's standing where, that it still could be blocked, but it would show. You would think, presumably, that there would be a bin that. What I'm thinking is, you may have just inadvertently put your stuff on top of his laptop or his computer that was already in the bin.
Well, that's possible. I may, because it was such a small laptop and it was gray and the bin was gray. That is a possibility. I didn't even think of that.
But
you might be right.
That could have happened, but obviously there's no. But when it goes through the machine, the TSA should have separated them and had it go back separately from it, in a different bin from your stuff.
I was the last person, so I don't know what happened. He may have taken off, not remembering that he had it in hand. And since there was nobody left, as soon as I basically was at the end of the TSA, they started taking off. I guess they go to a different line or something like that. So there wasn't even anybody usually there's like at the end where you collect your stuff, there's usually TSA. There was absolutely nobody there. Which was a very unusual situation. I've never seen that before.
Yeah, but there's got to be somebody manning the machine. So when it comes, look, I've had the same thing happen to me because I'm inadvertently. Look, I'm doing it quickly because I'm late for a flight. So what I'll say is I've done it before where I have put my stuff in the same bin as my computer. So the computer goes in first, and then I put my shoes and my jacket on top. And when it went through the machine, they took it out and told me I had to separate them. We're going to get right back into it with George in Stanford. So, George, what we were talking about before the break was that it may be possible that you put your stuff in the bin, not noticing that someone's laptop was in it.
Right. I mean, and I didn't even realize that until you mentioned it, and then also that it was a gray bin, and it was, it could almost camouflage if you're not paying attention, especially the craziness at the airport sometimes. So that might have been what really happened. I never even thought of that until speaking to you. And so that answers it. But the real issue is what I'm trying to get at. Look, if there's no criminal intent, and I can show that I've made several attempts in trying to find this guy prior to even when the police called me. Plus, when I finally got the police officer contact me, I said, "Look, contact the particular store I delivered it to," and then I asked, "Can you give me the contact for the person, and I'll see what happened." Since they said they'd emailed him, and he said he was going to pick it up and see what happened. And he said, "Oh, I can't give you personal information." Says, "Well, fine, and then give him my personal information. Have him contact me, because I'm trying to find out what's happened too." And that didn't happen.
When did you notice? But when did you notice that that the laptop was there? When you started emptying the bin?
Yeah, when I started emptying the bin and started putting yeah, exactly.
Why didn't you just leave it with the TSA?
The TSA wasn't even there. They weren't at the end of the line. Plus, I thought the guy had just left. Since I was the last person, I figured it must be the next to the last person. He'd probably come running back by the time I got, because our flight was just taking off. So I thought maybe he wasn't even paying attention. So he was running to the flight, and I was the last one there, and I would catch him somewhere there or in between or on the flight.
I guess it's easy for me to turn around and say that it would have been best just to leave it at the airport.
Oh, I understand that, but I've done this before many times where I've found phones and stuff like that. Matter of fact, I had a friend that when I was in London, I found a phone, and I went through a lot of trouble trying to find out who the owner is by calling different numbers until I found the owner, because I generally have lost the phone. I've lost a laptop myself, and it's not the damn hardware. It's all the information on there,
right.
And I know how that's so important to people that I felt was more important to get it back to the person. That's why I generally try to go the extra mile. It's not the first time I've tried to do this. This is the first time something like this has happened as a consequence of it. That's different.
Well,
but the real issue is what.
But real quick before we get into the issue is, because we got plenty of time, there's a phrase that no good deed goes,
Yeah, I know.
unpunished.
Now I know better. Yeah, I know.
Especially with the airport. But the thing is, it should be very clear in the video. But okay, so the issue is, what do you do to get them to drop any potential charges?
Correct. Yeah, because the state of mind, basically criminal intent. I mean, I obviously have plenty of proof that I had every intent to try to get it back to the individual. So I made more than the usual effort, even going to a local store so he could come right over. If the store had accommodated the situation. And the other thing is, where can I get a fair trial in Florida? If the witness is in Westchester, I have a right to confront my accuser. What happens if he wanted to? I don't know this for a fact, but after talking to a number of people, this is an issue that came up. What happens if he left it there, hoping that he could make an insurance claim because there's something wrong with the laptop, and I just was the useful idiot that proceeded. But anyway, the real thing is, I don't know what happened in between, but the thing is, I have evidence that I didn't try to take the thing. And the thing is, how can I get a fair trial in Florida if I can't confront my accuser, and all my witnesses and all my proofs are in Connecticut or New York?
Well, I would imagine that under the circumstance, I think that, again, it's Florida, but I'm hard-pressed to think that they're actually going to want to continue going forward with this. I mean, this guy in Westchester would have to be willing to press charges.
Well, that's what the officer was telling me, because that's why they grabbed me. That's why they hold me up. I had to bail out.
Man, so so have they filed formal charges in Florida?
That's what was really concerning. I said, "Where is the charge?" He says, "Oh, it was grand larceny." I said, "Grand larceny? It was a $300, a $600 laptop. It was an older laptop. It wasn't a brand new thing, and it didn't make any sense." So, and under their laws, I looked it up. It has to be over $1,000. So I said, this doesn't make any sense at all. So, I mean, even the people here were scratching their head. Why would Florida try to, extradite me? And for that type of thing, he said, for a laptop, they were scratching. Even if it was more valuable, they wouldn't extradite somebody. Connecticut wouldn't extradite somebody for a laptop. So they were scratching their head. They couldn't understand it.
And when's the hearing? When's the extradition hearing?
14th of next month.
I guess I would file a motion and show that there's no evidence. One, the big one for you would be that the value and controversy is doesn't make it's not an extraditable offense. So even if there is jurisdiction, it's not. I'd still raise the jurisdiction issue always, but here, even if there is evidence of jurisdiction, then it's still false because it's not an extraditable offense. And so those two are the big issues, and then you also have that there's no evidence of any criminal intent, which is obviously an element of the charge. This is a real crime they're charging you with.
Right. I mean, being that I try to return it, and several people were involved in trying to help me return it, and witnesses, that's why I can't understand this guy, why he's got a hot to trot, especially this is almost a year old, too. And then why wouldn't he at least connect me with the fellow, or meaning give me my contact information if it's inappropriate to give me his information, so that he can at least work it out. We can work it out and say what happened with the Apple Store type of situation.
Well, if if he's being considered the victim of a crime, you can't have any communication with him.
Oh, I didn't know that. Okay.
As long as there's charges filed, you can't communicate with them.
But if there's evidence there is no criminal intent, the only thing it could be is that I've been liable for not criminal intent, but maybe negligence at best, and that's not criminal.
Well, you try to give it back. I mean, I'm getting.
Yeah.
Yeah, you try to give it back, so it shouldn't really. But unfortunately, yeah, that's going to have to be something that you're going to have to argue. You don't talk to the police in Fort Lauderdale about that. You can't talk to them about this at all. But as far as the extradition hearing,
what about talking to the prosecutor and sending them evidence so that and affidavits that there was a continuous opportunity for me to try to get the contact with this guy and return his laptop, and I wasn't, to show that there wasn't any criminal intent, and it was returned to the Apple store. So anything is the problem, then why didn't the guy pick it up? If he got an email and he said he was going to pick it up,
and you have evidence that and you have witnesses that you brought it to the Apple store, right? I mean, as far as you know, does he have it back?
As far as I know, why would they proceed if he doesn't have it back? That's why the issue came up with some friends who talked about it, that maybe this is an insurance fraud and he deliberately left it or something like that, because they said, why wouldn't he have contacted the Apple store and, come back to the Apple store if he said he was coming there?
Well, I would imagine that, because if it was insurance fraud, I don't think so, because unless he was covered for his own negligence for leaving it there. We're up against a break, so we'll be back in just a few moments with the third of 3 hours of Anarchy Radio right here on LRN.FM with the No State Project. Don't go away. We'll be right back. This is a different kind of situation that we get here. This is probably the first of its kind there. This is George in Stamford, Connecticut, and to bring everyone up to speed on what happened, it looks like he may have picked up, somebody had a laptop in one of the bins. He may have just put his stuff on top of it, and then he noticed it after he got through the TSA. TSA is leaving, and he figured the guy, ahead of him had left it, and maybe they were on the same flight. He tried to get it to him, wasn't able to, wound up having to leave it at the Apple store in Westchester. So this started in Fort Lauderdale, and so he got it back. Apparently the guy wasn't satisfied with that, may not have gotten his computer back, and actually filed charges. Is that accurate?
I had to go to a second Apple store. The first one wasn't helping, but one in Stanford I finally had it delivered to, because they wouldn't accommodate contacting him or doing anything about it. I don't know why, but that's their policy, I guess. But I did it in Stanford, but it's an Apple store, yes.
Oh, yeah. So for anybody in a situation like that, leave the damn thing with the TSA. It sucks we have to do that, but there are people out. But I wanted to get back as far as the fraud. How would unless you had it insured for loss, that's the only thing I can think of as far as he was doing it possibly for insurance fraud, where he had it insured, and so possibly, what other ways would he be able to file for insurance about losing a laptop?
Yeah, because I couldn't figure anything why I didn't pick it up. If they're being truthful at the Apple store. Now I'm going back tomorrow to contact the guy, and I hope a friend can come with me, but I don't know if that's going to happen. But I'll have a audio tape going just in case, and say, can you at least provide me with the original emails to and from, and if for policy reasons you can't, can I give you the officer's thing and the people in Connecticut, so that you can at least give them that to show that everything was done in the proper fashion.
Did you let the police know? I don't know why I'm getting it. Did you let the police know that they should be able to contact the Stanford Apple store to confirm what you said, that you gave it back, that you don't have it?
I don't think the officer bothered to even check with the Apple store in Stanford. I did try to get back to him by phone, but I didn't realize what a screwed up system to have down in Fort Lauderdale, and I had his name slightly wrong. I thought it was a Spanish name. It was with a K, it was not with a C, and so the information may have been put on the wrong voicemail or something like that. Plus, I didn't know that they had two different parts and several different divisions that were completely different. One is corporate and one is non-corporate. I don't understand that crap, you know. It got really confusing to me when I called back just recently to try to sort things out. What the hell happened? You know what I mean?
Yeah, and do you have contact with, do you know who the prosecutor or the police officers that are handling this in Fort Lauderdale?
I know the police officer, but he seems to be hot to trot to get me no matter what. So I thought maybe the prosecutor was a better way to go.
Have you had contact with them?
No, I haven't had a chance yet. This only happened a couple of days ago, and I'm still researching all this crap and trying to sort it out.
Well, that may be a way to go. Try them, and they may have a more level head. And see that, hey, if it's that stacked against them, that it's obvious that there was no criminal intent, that you've given it back. It's not like you took it to the Mac store to sell it, or you went on Craigslist or try to sell it. Then that'd be pretty bad. But there's nothing like that. All you do have evidence that you don't have it. You gave it to the Mac store. You even tried to give it to a Mac store up in Westchester, and they weren't helpful. So I hate to say it, but maybe the prosecutor would be, that'd be a way to do it, to get them. If they withdraw it, then there wouldn't be a reason for an extradition hearing. Right.
That's what I thought might be the best thing, but I didn't know if going to the prosecutor was wise. I know going to this officer, even though I was willing to call him, might not be wise. Some person told me, because if I was told through a friend who called or talked to a detective up here and called down there. He said he seems too hot to trot to want to get you no matter what, type of thing. I said, what is with somebody like that? If there's,
Well, yeah. Well, what I hate to say this, but I have to. It may be the best, because talking to the police or the prosecutor about the merits of this is not good for you, because everything you say can and will be used against you. So it's probably better to have somebody else do the call, and it might be worth it to hire an attorney, not to represent you for the criminal proceeding, but just to act as an agent to speak with the cops or the prosecutor and say, look, I'm acting on behalf of George, and these are the facts. This is what are you aware that he doesn't have and has not had the computer, that he went to two separate Mac stores to get it back to the owner, and it's actually at a Mac store in Stanford, who has told the owner that they have it and he's able to get it back anytime.
Well, unfortunately, this is the really downside. When I went back just recently with the witness, he said our policies, after it's a certain time, we just dispose of them. That's the really bad part of this. If the guy doesn't pick it up, they dispose of them. I said, what the hell is that?
Okay, but as bad as that is, that's not something that can be held against you. You're not responsible for what the Mac store does after they've notified the owner and he hasn't picked it up. That's not on you. Who gives it? As far as for our purposes, it's not your concern, and you can't be held accountable for that. It's not your fault. It's on the Mac store, especially if they haven't. It's on the Mac store if they didn't notify him, but it's also ultimately on the owner for not going to go, or paying to have it shipped out to him. So I pretty strongly I would not speak to them directly. Do it through somebody else, and if they would only talk to an attorney, then it may. Like I said, I hate to do it, but it may be the way to get a quick fix to get this taken care of. I mean, it's not like you're going to need a $5,000 retainer just to have them make a phone call for you.
That's correct. Especially if I provide all the evidence and everything for him, plus the telephone number. So he's like a 10-minute situation, and if he's talks to a reasonable attorney general or whoever is involved down there, if you have reasonable people. This is the whole problem. Having reasonable people in this world, especially when they're in the judicial system.
Yeah, officers at a court, not so much. Yeah, I know. It really sucks because it sounds like you were trying to do the right thing, and I know I have found wallets, and I've always done what I can to get it back. Sometimes it's just returning it to the nearest store. I've not had something like that happen. I would hope that if I left my laptop, and that's the thing too, how distracted do you have to be to leave something as important as a damn laptop? I mean, the information that's on there is just too valuable, at least from my experience. Well, we're up against the break. Hey, I appreciate the call, George. So let me know what you hear, okay?
Oh, can I get a private consultation just in case, or your number for a private consult if I need one?
Yeah, it's on my website, markstevens.net.
All right, thank you.
Appreciate the call. My name is Mark Stevens. We'll be back here on the No Stay Project in just a few moments. Don't go away. Yes, welcome back to the No Stay Project. It's 4:20 Mountain Time. So, But I'm glad to be back with you live from the fortified compound in Mesa, Arizona. It's October 21st, 2017. Had a really good time doing the show live last week from Oceanside, so looking forward to being able to do that again. So we'll let everybody know about that. Fun playing some blues there. Bill, quite a harmonica player, so had a good time doing that. Beautiful area. It's 2 blocks off the water, so but still also wanting to do the show live from, if we can find a place right here in the valley. Would love to be able to do it here, especially since, there's no beach 2 blocks away, but still, the weather is pretty damn nice. So if you guys are familiar, someone can point me in the right direction to a place with good Wi-Fi that we can also play some blues after, get some music going. That'd be great. That would be a step in the right direction there. I wanted to discuss, because we're talking about on the chat, and this is a constant thing. Well, what do we do to try to stop these people? And I think it's part of the effectively defending ourselves. If we can make the stakes, if we can improve, our chances of success, and by driving up the stakes, the money aspect and the manpower aspect, that they, so not only are we defending against something, if we can file a claim against them and get them on the defense and get them having to spend time, money, and energy to defend against our claim, that may help. So what I've mentioned before is if we were to do an insurance claim for obvious damages that they are falsely charging you. The police officer is charging you with a code violation. He doesn't have the evidence to support that. He's assuming that the code applies, and under their own rules, it has to be proven beyond a reasonable doubt or by a preponderance of evidence. And that then you have collusion with the prosecutor and the judge, that the judge is allowing it to happen. And we can't file claims. I know there's going to be people that disagree with me here, that claim that we can file complaints in court against the judge and prosecutor. And technically, there is a remedy to do that, even though they have absolute immunity. If there's no evidence of jurisdiction, in some jurisdiction, some areas where, yes, you can maintain, but in practical terms, being able to overcome their defense of absolute, immunity or even qualified immunity, in practical terms, just doesn't happen. So the thing with the insurance claim, if you've not heard this before, is, and I have to get the templates, but people who are fighting this need to stay in touch with me and through the process and call the show and email me and let me know what's happening, and I can help. So I've been working with a number of people where we are filing insurance, claims against the insurance, and maybe it's something that may not work out at all. Maybe it'll only work out in some situations, but I envision that there'll be a call from someone who works in risk management saying, we've got a problem here. We can deny this guy's claim, but it opens the door for him to file in court. And if it's not dismissed immediately, even this, it's still going to cost time, money, and energy to have a prosecutor, or one of the county attorneys or city attorneys and a paralegal or two. It's still going to take some time, money, and energy to defend against this. It's going to cost this, it's going to cost the prosecutor's office money. Is this someone you really want to keep pursuing? But I look at it also from a standpoint that if we get it into court, on top of costing them time, money, and energy to defend against the claim in court, if we are able to get past the initial motion to dismiss and get into discovery, a judge and prosecutor, they have absolute immunity from civil liability. But if it's a claim against the insurance, the city, the municipality's insurance against the municipality, that absolute immunity doesn't, no, of course, their insurance, they don't have immunity. They're covered by the insurance. They are county or city employees, and if they hurt somebody, they're liable under the insurance. But there's still going to be witnesses. And the idea is, to me, I think there's a lot, one, I obviously think there's merit to it, but I like the idea that if we get them into discovery, then we can do depositions. It'll be a civil proceeding, and we can get depositions. So we can pull a judge off the bench, strip him of that stupid black robe, get him in front of a court reporter, and question him. And he doesn't have the power of contempt anymore. The prosecutor can't cry to him if he's in a deposition. Now, they can refuse to answer, of course. And then there's just more proceedings that their lawyers have to participate in, and it dries up the cost for their office. This is, okay? And so I don't know of another plausible way that we can get a prosecutor and a judge into a deposition, or get them on the witness stand. And yes, I know they can obviously file a motion to quash, but they're witnesses. They're the ones who caused the damage. That's why it's so important that if we get over the motion to dismiss that they file. And yeah, I know. Well, Mark, let's look at civil litigation there, torts like this, actions like this, they can get you tied up on appeals. Yeah, I know. But that's costing their office money. And that's why, it's like, are you somebody that they have to look at it? Risk management, that's their job, to assess the risk. Look, is Mark Stevens or someone Keith or Eyal, or are we really somebody that is worth prosecuting with these offenses? Because yes, if it goes on appeal, it's going to cost the office significant money. I know it's not their money, but it's still coming out of the office budget. Because how else are we going to get these judges and prosecutors out of court where they are sat down and have to answer questions? We're not going to do that. I've already tried. We're not going to do it by going to city council meetings and requesting it, the city council to do that, to pull the judges into a public forum outside of court where they have to answer questions. We know county commissioners are not going to require their judges to do that. They're just not going to do it. So this may be I think this is a plausible way to do that. To really, and to get the judges in their own, see, it's one thing for me to do it out of court, but to do it in a deposition with a sitting judge, yeah, that would be powerful if they can't prove their laws apply. We'll be back when we talk more about RICO and holding them accountable in just a moment. He's been on the show before. Let's welcome back Gabe.
Hey, Mark.
How you doing?
Good. How are you doing today?
I'm doing well. It's not Oceanside, and I'm not jamming with the guys. But hey, good material so far today. It's nice to be home too. That's why I missed the Wednesday broadcast because I was in California.
Okay. Well, cool. I'm glad you get a break at least once in a while.
I really would like to get something set up out here that we can have regular jam sessions and do the show live and get with people who are living here in the valley and are needing to learn how to effectively defend themselves in court. But we'll eventually turn a place up. We'll get something.
Oh yeah, yeah. It's incredibly important that people get role play. I remember when I used to live out in the woods, and we only had dial-up, so I could just had enough bandwidth to download your shows and listen. And I didn't realize at that time the significance of actually role playing and being in the hot seat. Once I went to court and started challenging them, the diversions and the red herrings that the judge threw up, and it's really interesting. They do anything they can to throw you off, and they know they're in the wrong. Is the incredible thing, and they're still willing to, at the same time as they know they're in the wrong, they still hold their delusion, believing these two self-contradictory ideas, also known as cognitive dissonance. But I want to reiterate again for anybody listening to the podcast, get in the Skype chat and role play. Get in the Skype chat and role play. You don't realize the significance of it if you haven't done it before. And the main thing I wanted to talk about is the topic of retrial and the risks therefrom. You did a really good job of hitting all the important points right in a row. I don't think you hit on the grounds that they claim to need to give you an increased punishment. And they say that there's two things, and those are if there is new information that comes up that they did not have at the time that makes you look worse, or if there is new information that has happened since, like say a probation violation, or if you committed another crime, then that would, in their words, give them grounds to punish you more heavily. But again, when we're talking about irrational criminal men who are merely men forcing us to pay them, they can and will do anything that they please. But this is what they claim the rules are and their burden is. But we know how they are as far as holding themselves to any sort of standard and burden. And one other thing, I don't know if this would be a factor, but they told me, that the judge in my situation did not impose the mandatory minimum of like $1,000 or $1,200, and he only charged me $100 because I brought up the issue. Well, I don't have any money, so where am I supposed to get this money? Are you telling me that that you are requiring me to convince somebody to give me money? Are you telling me that you're requiring me to go to a bank and try to convince them to give me a loan? Where and how do you expect me to get this money? And then, there's also the issue of what do you mean by money? By money, do you mean these things called Federal Reserve notes, which we know is not money?
Oh, I think it's defined and is accepted as currency, or money. So, is going to, and even if you're right by some definition, it still is defined as currency, and I think that's a losing argument. I wouldn't even, I don't think I'd raise that.
Right. Yeah, I mean, there was that guy who paid in, what is it, silver quarters or something, and, paid them the value in silver, but then they said, oh, well, you only gave us $50 in silver, so they totally screwed him on that, and And then there's also that one where he was paying his employees in gold coins or silver coins, and then they said, "Oh, well, that's fraud because you're giving them this extra money and you're putting it on the books as, the value listed on the coin, but the coin is worth more." So they can do both and contradict themselves.
Sure.
And they think they're equally right.
Yeah. Yeah, but obviously being retried is an issue. To get back to that, like you're saying, that there's new information, or if there's been another crime that that has happened in the interim, you have to take that into account if you're going to pursue an appeal.
Right, and that hasn't happened in my situation, but I am wondering about other things, because they may, like the lawyer that is doing the opening brief for me, and I'm doing a supplemental brief. She's trying to screw me by saying that I was continually interrupting and that I repeatedly complained, which is not the case. You can listen to the audio or the transcript and see that the judge continually interrupts me, and I just pause in the middle of my sentence and finish my sentence as soon as he's done talking.
Well, thing is, to effectively defend yourself, you have to be objecting. And some people are going to, depending on their experience and where they're, how they're, what their view of the world is. Obviously a prosecutor is going to think that you're being a jerk. They're going to characterize it as that you were interrupting. But as long as you were just objecting, you had a proper objection, and you weren't talking over the judge, then it's an unfound, it's not a valid criticism. You're there in a fight of your life, and to just sit, you can't look. An extreme example is something like what happened with Dave up in Boston over there. The lawyer that was helping him, and helping is in quotes, did not object to the prosecutor during his close, even though it was obvious that the prosecutor was making an argument that wasn't supported by any of the evidence that was that was presented at the trial. And the excuse that the lawyer gave is he doesn't like to object during an opening or closing statement. I'm like, are you out of your mind? They even did that in My Cousin Vinny, when he gets up for his opening statement and he says, everything he just said is BS. Thank you. And he objected, and everything other than thank you was stricken. So it's again, it comes down to, I think lawyers have an inherent bias against people like us, laymen. And that we go in and we have the audacity to try to defend ourselves, and they look at objections as just being disruptive, which is unfortunate. Hold on, we're up against the break, so hold on, Gabe. My name is Mark Stevens. We are going into the last segment of the big show for today. I'm going to try to get in also some discussion about RICO. And we'll keep Gabe on, and we'll talk more about appeal and the pitfalls that can come with that. Welcome back. We're talking with Gabe. So, are there any other questions regarding the decision, or what you need, as far as this appeal? I mean, do you think that, is there any evidence or any suggestion, something that would lead you to believe that there's a very high likelihood that if you are retried, it's going to be even worse of a fine?
That'd really be speculating. I really don't know. The judge, he plays as if he's friendly, but he's very like a pit bull, with interrupting and threatening violence. But at the end, he acted all friendly and gave me a really light sentence. A lot lighter than the other guys I spoke to in jail about the sentence they got was between 30 and 90 days, whereas I got 10 days and only ended up doing about 5 of those. I would assume it'd go in front of that same judge.
No, the retrial would not be in front of the same judge.
Okay. Yeah, I don't know. Is there any factors that you're aware of? I mean, I listed those two factors that they claim are what they need, but again, knowing that they're just men forcing us to pay them, is there any factors in your experience that they base their decision to increase punishment on?
The only other thing, the thing I can think of, and I don't have any actual proof that this was said. It was like I mentioned before that they could take into account, the prosecution could take into account the added expense of retrying you.
Right. Yeah, that's one thing I've been thinking about. Anything else? I mean, I mentioned the so-called mandatory minimum of like $1,000 that he didn't charge because I don't have any money. So I would assume, that they would probably take that into account, that I don't have any money, and the prosecutor might just drop it if it does get remanded back down for a retrial.
Yeah, in my experience, it's unless it's a politically hot issue, that they're not going to they won't go through the expense of retrying it.
Yeah, it's interesting. There's a lot of interesting things in my transcript. One of which is a earlier judge who recused herself, or had said that the prosecutor had submitted the evidence to overcome my motions, and I started to ask what it was, and she said, I suggest you leave while you can. And I asked, is threats of force and violence the only evidence you need to establish that this court has jurisdiction? And she says, Mr. Bryan, I can't give you legal advice. And then she started to call for a bailiff, so I got out of there. And then the so-called trial judge said she had not submitted that evidence yet. So it's, it is legal land. It is, where black is white and white is black. I'm wondering if you have any other ideas on other factors, or if you have another caller who has a more pressing issue, I'd be fine jumping off.
No, I actually jumped off the caller line and because we only had the one segment left, and I don't have anything. I mean, all I could do is speculate at this point, which really isn't going to help. What it comes down to is, because you don't have a situation where there's new information or another charge, you have a crapshoot. You don't know. You don't know.
Exactly.
You could say that, hey, the next judge won't be so harsh as far as cross-examination. Maybe the next judge will hold to the rules a little better. Maybe because it's being recharged, that they're going to want to stick to the rules a little better, so that if you are convicted, that you don't have really solid appealable issues again.
Right. I repeatedly made the point, I intend on pleading guilty here this entire time. I've just been trying to be informed. Why do you keep interrupting me and threatening me with force and violence instead of just informing me so that you could enable me to enter this informed and voluntary plea of guilty? Would you like me to enter an uninformed and involuntary plea of guilty? And I am thinking about getting assistance of counsel, or maybe even a lawyer to represent me in this next one. I don't know if I'll even be able to get up to Oregon if they do another trial. What are your thoughts on that? I heard you mention a little bit about counsel.
You know what I'm going to say. I mean, you've been doing this a while. You've been through trial. You've done a lot of the role playing. I'll answer for myself, though. I wouldn't use a lawyer. I have I'm very biased based on my experience with lawyers. I don't trust them.
Good reason.
Even if they're very good at their craft, they are cost prohibitive. The really good ones are going to they're not even going to look at you for less than a $50,000 retainer. I'm working with someone now where they're saying that there's a lawyer who wanted $5,000 a day for trial, and we're not even talking murder, rape, or a real crime. $5,000 a day. That is insane. And I don't even know if he's
racket.
Good. Yeah, and I don't even know. I can't even say if he's a good lawyer. I'm not going to know anything about him other than he wants $5,000 a day. If somebody wants $5,000 a day, if their name isn't Jerry Spence, walk away. Because Jerry Spence and his firm are the only ones that I would think come even close to being worth that. Because at least you're guaranteeing you're going to walk away eventually. But so I can't. The only time I recommend an attorney for someone who is so bad at public speaking and is so stressed out and has social anxiety to a point where they can't speak for themselves, they have no choice. I have, for someone like that, I would still recommend at least trying to go to an NLP practitioner or a really good psychologist to try to overcome that so they could do it themselves. But other than that, I don't look. And if you're charged with a real crime, then like murder, rape, or something like that, then you probably should get an attorney. You certainly don't want to cut your teeth on a real crime. That's why I tell people when it's possession, they're looking at 10, 20, or 30 years. Do you really want to cut? It's the first time in court. Do you really want to get your experience when your life is at stake? No.
Yeah, so, that's an interesting suggestion. Yeah, there's a lot of good NLP practitioners that could help you with that. For me, with not having money, then I would be, limited to public defender. And, that being the case, I'd be leaning more toward assistance of counsel. What do you think about that in Oregon? If
they can be standby, because I know you probably can because you're not in California. If they could be standby, and this way they're actually assisting you and can offer argument and make objections, great. And I hate, if you need to do it, you need to do it. And the problem you come into is, like we mentioned before, if they don't want to play ball and they won't withdraw, and if they do want to withdraw, the judge won't let them. Now you're stuck with a mouthpiece that is going to be basically assisting the prosecution.
So the judge could, of his own volition, say, oh, well, I'm moving them from counsel to being your representative?
They can go from standby counsel to representative. Yes, absolutely. That is true. Does it happen often? Not my experience, but it's something you got to throw in the mix. You may be shut down completely by your own attorney, and I mentioned already the only remedies you have available to rectify that. And even that may not help. Like I mentioned with Dave here in Phoenix. It was horrible. Horrible. This guy did not get to see his daughter's first few development years. It was awful. And yes, we did the appeal, and he got turned down every step of the way. It was absolutely awful. So unfortunately, hey, Gabe, I appreciate the call. We're out of time.
Yeah. Next show, I want to hear more about the situation in Keene when you tried to help out Ian Freeman and he bailed on the Socratic method.
Okay, we can do that.
Mark, thank you.
All right, so it's been October 21st, live from the fortified compound in Mesa, Arizona, here the No Stay Project. I will be live on Wednesday, so till then, salud!